Good morning. This hearing is called to order. This is a public hearing of the City Council Committee on Labor and Civil Service. The purpose of this public hearing is to hear testimony on bill numbers 190315 and 190316. I recognize the presence of a quorum of committee members. Members of the committee in attendance are to my right, Councilman Al Taubenberger, to my left, Councilman Derek Green, and I also want to note the presence of Council President Darrell Clark. Before we begin, I want to ask any of my colleagues, do any of you want to make any comments on the bills? Let me just note for the record, and particularly for the benefit of those who are watching at home, I want to give you a little background relative to process. In about January of this year, I had an opportunity to meet with residents of the 9th Councilmatic District that I represent, who are also workers in the parking industry. After communicating with them, I also met with members of the parking industry. I informed them that I would be working on some legislation relative to the issues that were presented to me. On March the 14th, I introduced a resolution calling on this committee to hold hearings regarding parking workers deserving a living wage. After the introduction of the resolution, I attended a press conference hosted by 32BJ on March the 19th. At this press conference, we heard from 32BJ, Power, Steve Hersenberg from the Keystone Research Center, and several parking workers. On April the 8th, this committee held the hearing for parking workers deserving a living wage. The purpose of this hearing was to shine a light on the issue and let people hear the stories of parking workers. At this hearing, we not only heard about parking workers working long hours at low pay and struggling to get by, we also heard about issues regarding staffing and fears about job security and being fired for speaking out, and about harsh working conditions and just simply trying to organize. On April the 16th, I met with representatives from the industry to let them know that I would be introducing two bills. One to address minimum staffing requirements, and one to create just cause provisions for firing of employees. When I met with representatives from the parking industry, and I want my constituents to pay very close attention to this, I shared with them the two bills being considered today. Did you hear what I just said? I did not move forward with the introduction of these bills without letting the parking industry know exactly what my intent was, so that they would have an opportunity to vet it. I also gave the Chamber of Commerce a heads up that I had already been working with the parking industry, that they had copies of the bills before their introduction on April the 25th. And since the bills were introduced, I've had numerous in-person meetings and conversations with individuals on both sides of the debate. And for the record, that's my standard operating procedure. I don't care if you are for or against a measure that I have introduced. I am not going to do so without hearing perspectives on both sides of the aisle, because that's my responsibility. I want to give you this background information because I expect today you're going to hear from some people testifying that this legislation is moving too fast, or that there hasn't been time to discuss amendments. But I want you to know that it's been almost a month since the first hearing and my meeting to discuss these two bills, and I have yet to receive any proposed amendments. All I have heard is, don't do this. Well, I think we have a moral imperative to do this, and you'll hear when the bills are explained later on why that it is so. I also want to note for the record that I don't believe these bills are anti-business. The Greater Philadelphia Chamber of Commerce knows that Cherelle Parker has proudly and will continue to proudly support their newly launched Neighborhood Growth Project. I wholeheartedly agree with it when it notes that for Philadelphia to reach its full potential, we must create more high-quality, high-wage, 21st century jobs and build an inclusive economy with opportunity for all. I would argue that this is what both of these bills are striving to do. And for the record, I am also of the opinion that one can be both pro-business and pro-worker at the same time, okay? I also want to note for members of the industry who are present here, when we met, you were very clear in communicating to me through your research the burden that Philadelphia's tax structure has on the industry. I committed to you, and I've said it publicly, I want to say it publicly again, after we work through these two bills, and it is my hope that both of them will not only get enough votes to pass through this committee, but to also pass through the whole council. I have committed to working with the industry on coming up with strategies and ways that we can develop a revenue-neutral solution that can reduce the tax burden on the industry. Workers, did you hear me? I'm here today, and we've introduced this to protect workers in this very specific industry, but I am also committed to working with the industry to reduce its tax burden. So I'm a black legislator. Listen. I am an African-American legislator who happens to be a woman who will not allow anyone to put me in the box to say I can only work here or I can only work there. And so it is with this in mind that I would ask the clerk to please call up the first panel. And also want to note for the record, to my right, Councilwoman Maria Quinonez Sanchez has arrived, and also to my left that Councilwoman Helen Gim has arrived. Thank you both for being here. Will the clerk please read the title of the bills?
Bill number 190315, an ordinance amending Title IX of the Philadelphia Code entitled Regulation of Businesses, Trades, and Professions by adding a new Chapter 9-4700 to provide protections for parking employees against wrongful discharge under certain terms and conditions. And Bill number 190316, an ordinance amending Section 9-601 of the Philadelphia Code entitled Garages, Parking Lots, Sales Lots, and Sales Showrooms to add requirements for sufficient staff for parking garages, parking lots, and valet services under certain terms and conditions.
The clerk will please call the first panel of witnesses to testify.
Rich Laser and David Perry.
Please state your name for the record and proceed with your testimony.
Good morning, Chair Parker and members of the committee. My name is Richard Laser, and I'm Deputy Mayor for Labor. I appear before you today to testify on Bill number 190315. This bill is the first in the nation ordinance that explicitly will provide workplace protections for parking employees in Philadelphia. It will require that employees document either just cause or a bona fide economic reason in the event that a parking employee is discharged from their place of work. In prior testimony before this committee, I noted that the median wage of workers in this industry is just $9.50 an hour, and almost 70% of parking employees earn less than the median income for Philadelphia. We have already called upon our colleagues in Harrisburg to increase the minimum wage in the Commonwealth, and will continue to do so, but this bill touches on the other side of the issue. Hard-working Philadelphians deserve some level of job security. In prior testimony before this committee, we heard directly from parking workers about how they are constantly worried about being fired, transferred, or rescheduled at a moment's notice. These are folks who want to work hard and provide stability for their families, but are unable to do so because they get no voice and no agency at their place of employment. To be clear, Bill number 190315 does not protect problem employees, and it does not stop employers from right-sizing a workplace, if that's what the economics dictate. But it does require that employers must document their actions, and it provides workers who may be aggrieved with an opportunity to let their voice be heard. All of this aligns with Philadelphia's long-term goals around inclusive growth, and the administration supports the intent of this bill. Thank you again for the opportunity to testify, and I'm here to answer any questions at this time.
Good morning, Chair Parker and members of City Council. I am David Perry, Commissioner of Licenses and Inspections. Today, I am here to provide testimony on Bill Number 190316, which, if enacted, will amend Section 9601 of the Philadelphia Code entitled Garages, Parking Lots, Sales Lots, and Sales Showrooms. The bill would amend the license requirements for parking facilities to include a provision for adequate staffing levels. Among other requirements, it stipulates that for a public parking lot license to be issued, the Department of Licenses and Inspections shall approve evidence that the facility has adequate staffing to maintain good order and ensure the safety of employees and customers. It also requires the department to investigate complaints of insufficient staffing. We understand that the primary objectives are to protect the physical safety of employees and customers from criminal activity and to ensure smooth traffic order into and out of parking facilities such that safety hazards are not created within the public right-of-way. We envision requiring parking lot and garage operators to submit for approval a descriptive plan prepared by a qualified individual that includes the minimum number of employees classified by job duty and shift, all necessary security and operational equipment, the design vehicle flow rates, and other such information necessary to ensure the operational adequacy of the facility. Suspected violations of this bill will be enforced primarily through complaint response, although periodic spot inspections will also be performed. While the department will be responsible for all 149 currently licensed public garages and lots, it is our understanding that enforcement of on-street valet service will continue to be the responsibility of the Philadelphia Parking Authority. To implement and maintain a credible and responsive enforcement effort for this bill, the department has determined that an increase of one code enforcement officer with a vehicle to the department's budget will be necessary. The Department of Licenses and Inspections supports this bill and is prepared to enforce with the acquisition of necessary resources should it become law. Thank you for the opportunity to provide the department's testimony. I will be happy to respond to questions at this time.
Thank you, Mr. Laser and Commissioner Perry, for your support of both of these bills that were chiefly co-sponsored by Councilmember Derek Green, Councilwoman Helen Gim, and Councilwoman Maria Quinones Sanchez. With this in mind, Mr. Laser, I understand that the implementation of this legislation is also being considered along with the implementation of newer legislation like Fair Work Week, future legislation like the Domestic Workers Bill of Rights being championed by Councilwoman Sanchez, and older legislation that have also been passed by this council in previous years. I just want to note for the record that as a member of this body, I am committed to ensuring that there is enough money for all of these bills to be successfully implemented and to make sure that we have proper labor and enforcement going forward. I also want to note for the record that as a result of our communication with you, you will note that there are two amendments being offered today to push back the implementation date by 90 days to allow for thorough planning on your behalf. And we would not have thought about changing that date had you not said that you needed additional time.
Correct.
In addition to that, Commissioner Perry, I want to thank you for your efforts to ensure the safety of Philadelphians via inspections and enforcement. We understand your request for a code enforcement officer for a vehicle in order to successfully implement Bill number 190316 in particular, and we will support this request 100% during this budget cycle to ensure that you have the dollars that you need. And after our discussion with you regarding these bills, again, we are amending this bill to push back the implementation date to January the 1st, 2020, to allow for thorough planning on behalf of your department. So again, just for the record, during communications, we learned that both of the implementation dates would be a challenge, and we adjusted the legislation as such. Do any of my other colleagues have any comments, any questions? Councilwoman Sanchez.
Thank you, Madam Chairwoman, and thank you for your willingness to create an important scenario in the legislative process in council, which is how do we get to a win-win, right? How do we lift all of these workers out of poverty and get them to family-sustaining jobs, and how do we recognize some of the challenges that exist in the industry? I don't know if either of the panelists is willing to speak to the parking industry. For years has been claiming this disparate impact based on our tax system. There was a task force that was set up. They've submitted a bunch of stuff around investigations of parking lots. Can anybody speak to where we are? It was mainly around revenue and the issue of small parking lot attendants that they felt were not duly paying their taxes. Can any of you speak to that, where we are with that process?
Councilwoman, I apologize, I don't have that information, but I can talk to the finance department and get back to you with an answer on that and supply it to the chair.
Yeah.
But I do remember that. It was a few years back, but I do remember that happening and you being a part of it.
Yeah, I think that's hugely important, because while there are some of the bigger international companies that we want to make sure that they come into the city and they're not exploitive, we also are aware of smaller operators who have access, as Councilman Parker just mentioned, valet and other things that we could be doing a better job. As we look for enforcement of this so that we ensure that everybody is playing by the same rules, as part of the operationalizing of this process, Commissioner, you mentioned there's 149 licenses. When the industry came forward, they said that there were many more operators. How have we closed that gap between who we have that's licensed and wants to play fair and who we think is operating without that?
Well, there may be a misunderstanding as to what's considered to be a public parking lot. So I'm going to have to look at the numbers and locations that they claim are not currently licensed, and we'll be happy to provide enforcement around that issue. But we have currently 149 licenses. They would represent the parking lots in which a customer would have to pay in order to park in that lot. If there's other lots that are out there in which there is no fee for parking, if it's accessory to a shopping center or to a store, that would not be part of the public parking lot license.
Okay, thank you. Thank you, Madam Chair.
Thank you. Chair recognizes Councilman Green.
Thank you, Madam Chair. Mr. Perry, Mr. Laser, I wanted to just follow up on some of the questions from Councilman Sanchez. Currently, what is the enforcement process that LNI uses for parking lots?
The only enforcement that we currently do would be if we got a complaint about how a parking lot was operating. For instance, if there were too many cars parked on the lot in which the cars were being stacked as opposed to parking in individual parking spaces, that would technically be a violation of the zoning code. So we have a 4-person unit that's responsible for business compliance inspections, and parking lots would currently be handled by one of those 4 individuals. So currently, it's all based on complaints being received by the department.
And that 4-person unit is responsible for what other type of enforcement?
They do other types of code enforcement for business licensure, for zoning requirements, for parking. Mainly, their enforcement it concerns itself around zoning issues.
Okay. So most of the focus is on zoning primarily?
That's correct.
And so from your understanding and recollection, how many complaints have LNI received historically regarding parking lots being operated efficiently or not being licensed?
That I'll have to research and get you that information, Councilman. I do not have that information with me today.
Okay. And with the nature of those complaints that they have received, have they come from constituents, employees, other people? What's the nature of how those complaints have come from your understanding?
Yeah, the ones that I'm familiar with generally come from customers, and they come in through 311. They're the ones that I'm familiar with. We get on occasion complaints about incorrect pricing at paid parking lots. That's also a complaint that we get, or we'll get a complaint from a community group or an individual that a parking lot's operating in violation of the zoning code.
So that would be a lot where someone is charging people to park cars on a lot, but it's not licensed to do that.
That's correct.
And that's going to what Councilman Sanchez was saying, that in reference to the 149 lots or non-lots, we're trying to get understanding of what is licensed, what is not licensed.
Yeah, like I said, we have 149 that are licensed. The ones that are non-licensed get shut down right away, so we don't knowingly allow them to continue to operate. But I'd have to see if the industry feels that there's lots out there that aren't properly licensed or zoned, and we would certainly follow up and provide enforcement over those facilities.
Do you think there's a need for additional resources for enforcement?
Well, we could always use more enforcement. We tried to look at the new requirements of this bill and figure out what would be the minimum number of people that we would need to respond to complaints, and also do some proactive inspections that we feel are really necessary in order to provide a level playing field.
Based on your perspective, do you believe there's a significant amount of revenue that the city is losing from unlicensed parking lot operators that should be paying taxes and providing services to people in the city of Philadelphia?
That I wouldn't know, because L&I does not get involved in the tax collection part of the enforcement effort, so I think that would be an appropriate question to ask to the Revenue Department.
And I think Mr. Laser said he would provide additional information on revenue. Because I guess trying to get an understanding how many are these lots that are out there that are not licensed or that don't have the proper licensing, that are not only not probably paying the employees a certain way, but also probably treating employees in a substandard way, as well as customers as well. So I think there's some information that would be needed to provide that information, because these unlicensed entities are not only shortchanging the city of Philadelphia in revenue that the city should be receiving, but also probably taking advantage of employees who are working there in a substandard way.
Absolutely.
Okay. Thank you, Madam Chair.
Chair recognizes Councilwoman Gimm.
Thank you very much, Madam Chair, and thank you. Good morning.
Good morning.
So, we had been working together a little bit about how to strengthen your office, Mr. Laser, and so I think that's one of the most important things I'm interested in. As we work to expand our labor laws, one of the most important things is that we can pass laws, but we need to enforce them. And this city really needs a clear communication, both with our employers and especially with educating employees, that they have rights in the city, that we have worked hard to get a wage theft law through. We have a paid sick leave law. There are certainly existing laws around overtime and other types of things that should be enforced, including the minimum wage, quite honestly. And I'd like to see, when we did the Fair Work Week law together, we talked about increasing the number of staff in your office from 1 to 3, is that right?
Yes, there's currently 3 folks in that office now.
Great.
In the proposed budget that's before you, there will be 2 additional folks in the budget for that office.
Excellent. So we're going to move from 3 to 5, is that correct?
Correct.
As of July?
Yes.
Okay. And then do you anticipate that this, should this law pass, that we would need to add anybody else to your office? Because for me, I feel like, we need a whole education unit, we need an enforcement unit within this city, because, we've got a lot of laws on the books that I think are great, but I don't know how well they're being followed.
Correct. So we are currently, I have the staff currently looking now at the proposed bill on domestic workers' bill of rights, and also at this to see if there'll be additional resources needed to help with implementation and communication of these ordinances.
And
hopefully
how
that's
soon
something
do you think that you would make a recommendation to council or to the administration on that?
I think in the next week or so. We've been working on it since this bill was introduced, so probably the next couple weeks.
All right, good. I look forward to that. Thank you.
Are there any other questions for this panel? Councilman Green?
Yeah, one quick question. Thank you, Madam Chair. Mr. Perry, will there be any regulations needed for implementation of this legislation?
Yeah, we are considering regulations because part of the implementation would require the parking lot operators to provide us with a plan. So we want to be able to figure out what does that plan encompass, who signs off on that plan as it being adequate, especially with regards to maintaining proper traffic flow in the public right-of-way. We do get complaints that some of these parking garages have inadequate staffing, which is causing backups in traffic along major corridors, which is interfering with SEPTA operations. So we need the operators to give us a plan that talks about what's the flow rate, what's the minimum number of employees. And I think the best way of getting all that information together is through a regulation process. So we anticipate doing at least some regulations.
Okay. Thank you, Madam Chair.
Thank you. Thank you to the panel.
Thank you.
Will the clerk please call the next panel of witnesses to testify on this bill?
Reverend Greg Holston and Leo Gertner.
Good morning to each of you. We want to thank you for being here. Just please state your name for the record.
Hi, good morning, committee. My name is Leo Gertner.
Reverend Gregory Holston. Okay. Again, my name is Reverend Gregory Holston. I'm the Executive Director of Power and the Senior Pastor at James Memorial United Methodist Church in the Germantown section of Philadelphia. Power is 65 plus congregations across the city of Philadelphia and the surrounding areas, dedicated to building a community of opportunity that work for all. We have stood with airport workers, we have stood with fast food workers, we've stood with and still stand with hotel workers, we've stood with security workers and janitors and workers all over this city for the last 9 years. And we're proud to say we're standing with parking attendants today to fight for a just cause and fair working conditions. All of us here understand the devastation that is going on in our community. We recognize the 26% poverty rate is basically a state of emergency here in the city of Philadelphia. We recognize that almost 400,000 people live in poverty in this city. Almost 200,000 live in deep poverty. And for some, for an individual, that's about $5,500, $5,600 a year, a little more than $100 a week. We look at those numbers and we recognize that there are human lives behind those numbers, suffering each and every day in our city. And so what can people of faith do but stand with workers? Because one of the ways that we can move people out of poverty is simply standing with workers for fair wages, for just hiring situations, and just conditions on their job. If we're going to pull this city to be the first-class city that we say it's going to be, it has to start with standing with workers like these who are here today. And so we're proud to stand with them. And so here today we come to fix an injustice in our city, to make a dent in the poverty rate, which means a scourge on our city. Men and women who park cars in this city are paid low wages and treated as if they're expendable. In fact, they are routinely mistreated and are alone and sometimes in unsafe working conditions. Meanwhile, the Philadelphia parking industry makes $440 million each year. That's a moral outrage, a disgrace that under these gleaming buildings are men and women, mostly black people, many African immigrant, working full-time, sometimes 2 or 3 jobs, and still living in poverty. The parking companies cater to many of the wealthy visitors and commuters who come to our city. Yet when these parking workers are done with their 12 and 14-hour shifts, they go home to some of the most impoverished neighborhoods in our city. Parking workers leave the garage underneath skyscrapers and luxury hotels and return to neighborhoods like Southwest Philly and Germantown and North Philadelphia, where they worry about how they will afford their rent and bills, and if their children are safe while they work 60 to 70 hours per week. The parking industry imports profit from outside of the city and exports poverty to our neighborhoods. Let me say that again. The parking industry imports profit from outside the city and exports poverty to our neighbors. And I will even go further. They take that profit home to their places, and that profit does not stay right here in this city. We talk a lot about poverty in Philadelphia, and as I said earlier, and we talk about programs and advocacies and grants and training and STEM programs and early childhood education and affordable housing. The business, the philanthropic education, and nearly every sector in the city all agree that poverty is holding us back. They discuss plans and programs and pipelines and agree that something must be done. This council and the administration have actually begun to take action on these issues: Fair Work Week, 21st century wage standard, prevailing wage for service workers. But here we come today to again try to prove the lives of 1,000 low-wage black workers who are fighting to make parking jobs good jobs. And that's the key, because we talk about manufacturing jobs being good jobs. But manufacturing jobs were only good jobs because workers on those jobs unionized themselves and fought for the right to have good wages and the good working conditions. And so these parking workers stand in the same tradition as those in those manufacturing plants over 100 years ago. They stand in the same tradition to be able to fight for better working conditions for their families as well. And so we know that parking industry will try to stop this progress. We know that in spite of all the talk about poverty, doing the one thing that is sure to improve our poverty rate, creating good jobs, is somehow controversial to this lucrative industry and its lobbyists. The parking industry is a Goliath in Philadelphia, raking in nearly $500 million each year, and it could not do it without the city. The parking industry does more than just lease parking spaces for an hour or a day or a month. The parking industry is a developer in its own right, making deals worth hundreds of millions of dollars to develop space above their lots. The industry comes to the city for zoning variances and buildings, and the buildings they build often get massive tax breaks. The parking industry even has direct contracts with the city. There is nothing wrong with an industry thriving while trying to provide a service. However, the breakdown occurs when that same industry mistreats its workers, automates its workers, and puts them in unsafe conditions while paying poverty wages. The problem is not their profit, it is that they do it while making the city's poverty rate even worse. In the parking industry, workers fear for their jobs, never knowing if they will be indiscriminately fired. In the parking industry, workers must work multiple hours to get by, while companies race to automate so they eventually don't have to employ anyone. Meanwhile, parking workers and parking customers increasingly less safe as lots go under or unstaffed. The parking industry is not looking to solve problems for our city. It is an industry that seems to be bent on creating more. The parking industry in the city can do better. The prosperity that drives into Center City and the business district must make it to all of our neighborhoods and communities. The only way to truly deal with the city's deep poverty problem is through good jobs. And today, City Council can lead the way for 1,000 good jobs for Philadelphians. If we stand together and work together and build together so that they have good working conditions, so they won't be fired indiscriminately, which, by the way, won't cost this industry one extra dollar to treat workers fairly. So today I ask you, and Power asks you to stand with workers, because when you stand with workers, you stand with the entire city of Philadelphia. Thank you.
Thank you, Reverend. Thank you, Council Member Parker and committee members for the opportunity to testify today. My name is Leo Gertner. I'm a staff attorney for the National Employment Law Project. We're a nonprofit, nonpartisan research and advocacy organization specializing in employment policy. We're based in New York with offices in Washington, D.C. and throughout the country. We partner with federal, state, and local lawmakers on a wide range of workforce issues like unemployment insurance, the gig economy, workers' comp, and as is the case for the hearing today, fair employment practices like just cause. We testify in strong support of Bill number 1903315 because parking workers perform essential services in the city of Philadelphia, but unfortunately working conditions in the industry create serious instability for workers, their families, and the industry itself. The present bill would establish a system to ensure basic fairness and equal treatment in the very profitable parking industry with numerous benefits to workers, employers, in the city. I'm just going to focus on a few of these benefits in the interest of time. First, a just cause standard in the parking industry would create a simple and straightforward system to ensure all parking workers are held to clear standards and treated equally. Today, employers basically have a blank check to mistreat and discharge workers for any reason at all. Workers can be and are fired for unfair reasons or no reason at all for things as simple as taking necessary bathroom breaks, calling out or missing a shift, customer complaints that are either minor or not investigated, minor disputes between workers, and other minor issues that do not merit termination. But more often than not, employees don't even know why they're terminated, much less if it's actually related to their jobs. Workers deserve to receive notice of performance issues and a chance to correct them if they are legitimate. And we believe that describes basic fairness. The burden on employers, we also believe, is minimal. The current bill would simply require employers to provide a legitimate business reason when making a major change to an employee's status, whether it's termination or hours reduction. Without this simple requirement, employers end up losing valuable employees. It's just not burdensome to require employers to give workers a reason. I'm just going to list a few of the benefits also that the system will create aside from fairness and equality, which are not to be underrated. A just cause system would raise standards for this entire low-wage industry and therefore result in lower turnover, safer parking facilities, job security, fewer worker injuries, and better customer service. Because state law prevents increases in the minimum wage at the city level, laws that raise standards, such as the proposed Just Cause bill, but also the minimum staffing bill, provide an opportunity for major improvements for an industry plagued with low pay and weak worker protections. Throughout the country, cities are raising standards for workers with sick pay, family leave, fair work week legislation, and so forth. This is just in line with that and nothing surprising. The bill would also create a safer industry. High turnover means that the industry fails to retain qualified and experienced workers, which is a detriment to all parties. Workers are already overburdened with double shifts, long work weeks, assignments where one person alone is expected to service a garage, and other situations that require adequate staffing and adequately trained personnel. The majority of workers report right now that they show up to work sick. Just Cause would provide greater incentives to the parking garage employers to train staff and ensure protocols are followed. Currently, the industry suffers from a culture where workers are treated as disposable and easily replaced, and that's wrong. But this is also a better deal for employers. Not only does Just Cause create fairness, it has the potential to improve productivity and customer satisfaction. Numerous studies show that a more stable and qualified workforce helps reduce costs associated with turnover, training, and low productivity. Fewer accidents and injuries that result from a better qualified workforce also help control costs and ensure that customers and workers both feel safe using parking facilities in the city. Employers stand to benefit from the Just Cause system. In conclusion, Just Cause is a system based on common sense and basic fairness. Philadelphia's parking industry loses far too many good workers to arbitrary and capricious treatment, which has far-ranging effects not only for workers who are already struggling to survive, but also on the employers in the city's wider economy, which benefits from a more skilled and stable workforce. In short, the current bill is a soundly written bill that improves employment conditions for a vulnerable group of workers in a way that we believe is manageable for businesses. Thank you.
Are there any questions or comments for members of this panel? We want to thank you both for your testimony. Thank you very much.
Thank you, Cherelle.
Will the clerk please call the next witnesses on the next panel to testify on these bills?
Rob Wonderling, Darwin Beauvais, and Marjorie Obad.
You go first.
Okay.
We want to thank you all for being here, and just to note for the record that Stephen Bradley of the African American Chamber of Commerce was scheduled to attend. He has a conflict and cannot, but he did provide a written testimony on this issue. We want to thank you for being here, and just please state your name for the record and then proceed with your testimony.
Good morning. My name is Rob Wonderling, and I serve as the President and CEO of the Chamber of Commerce for Greater Philadelphia. I'm here today to offer testimony in opposition to Bills 190315 and 190316. The Chamber's mission is to attract, retain, and grow jobs for the city and our region. We follow principles of economic competitiveness to guide our public policy. We believe that government at all levels must operate in an efficient way to maximize the services that it provides, and the Chamber of Commerce for Greater Philadelphia works with a myriad of organizations to advance an agenda leading to economic growth and prosperity. Through our Neighborhood Growth Project, which the majority of council members have already endorsed, as well as other initiatives. As currently written, both bills will provide a negative impact on industries far beyond the parking industry. But also, we oppose the bill and its process from introduction to hearing, and to date, the lack of engagement around the introduction with the broader business community. On previous bills, such as Bill 180469, which mandated predictive schedules, City Council individually and collectively engaged in efforts to bring diverse parties around the table and have a conversation that informed the legislative outcome, that struck a proper balance for employees and employers. Not all businesses and organizations are alike. They range in size, industry, geography, hours of operation, and personnel needs. They should be able to utilize a full set of tools in order to manage their businesses, employees, and competitive advantage, especially when they are overburdened by an exhaustive regulatory environment. It's no secret the parking industry has to compete with a 22.5% parking tax rate while also paying real estate taxes, the BIRT and UNO tax, in addition to managing facility costs to maintain parking lots and manage customer demand related to the use of those parking lots. Increased taxes and fees have been levied on the parking industry in this city since 2008. Over the last 5 years, the parking industry has lost over 5,000 parking spaces, which has directly led to the loss of close to 300 jobs. We're at a critical time in the city of Philadelphia. We must do away with the zero-sum game that hurts employees and valuable job creation opportunities. We want to inject a critical question into this process around these two proposed pieces of legislation, and that is, will they create jobs? We don't think these two bills does that. For these set of bills, we do not believe that the debatable ends justify the means, given how onerous this legislation is for employers within the parking industry and the industries outlined in the bill. From a practical standpoint, the, quote, reduction in hours, close quote, provision, which requires employers to have, quote, just cause, close quote, for reduction in hours is burdensome. Many parking employees, such as valet attendants, only work a handful of hours per week, rendering 15% a very slim margin of errors for employers dealing with that particular scheduling issue. Similarly, many parking employers' staffing needs are heavily impacted by unpredictable and outside forces such as the weather, customer activity beyond the employer's control, and other miscellaneous scheduling challenges. The proposed ordinance suffers additional challenge as the language in the bill seeks to regulate more than just private parking entities. The way the bill is currently written, auto dealerships, restaurants, and hotels that provide valet services may be impacted. The Philadelphia International Airport and the Philadelphia Parking Authority, a state agency that the city has no authority to regulate based on state law, would be subject to the onerous provisions. If such a bill passes, it will continue the trend of this local government where it inserts itself and acts as the HR department for private businesses in Philadelphia. The proposed ordinance imposing a just cause standard upon parking employers for all employee terminations is almost certainly preempted in whole or in part by the National Labor Relations Act, 29 U.S.C. Code 151, which guarantees the right of private sector employees to organize and engage in collective bargaining. Further, the NLRA prohibits retaliation against any employer for engaging in concerted protected activities, such as attempting to address current terms and conditions of employment with fellow co-workers. This is already regulated at the highest level of government and is not needed at the local level. And although the overly prescriptive, quote, just cause, close quote, provision is targeted at the parking industry in this bill, we believe it's only a matter of time before other industries are added and it becomes the general law protecting all private employees in Philadelphia. We oppose both bills and in particular the passage that has led us to this point in time and at this hearing. It has not allowed enough time for a thoughtful discussion on the issue within the broader business and civic community, and we'd ask members of this committee to lodge a vote no on the two bills. Thank you.
Okay. And listen, I'm saying okay for a reason. I was at a hearing that was held in this body probably about 3 weeks ago, and some people came in here who weren't pleased with my vote on a matter. And when I tell you that they were disrespectful, it was very distasteful. And so what I've committed to is I will not allow my colleagues or anyone else to experience what I experienced that day when those people weren't forced to be respectful of this chamber. So we have our position, but let me tell you, you don't want to be where I was that day. It wasn't a comfortable feeling. So I thank you all for your understanding.
Good morning. My name is Darwin Beauvais. I'm an attorney at Dilworth Paxson. This is my law partner, Marjorie Abad. We too are here to give you voice our opposition of the bill. But however, our intent for this body is not to discuss whether the public policy issues of the bill. We actually have researched that the bill is preempted. The chamber has noted that. We looked into that. Ms. Obad is the chair of our Labor and Employment Department. She can speak more to that, but before we get into that, I just want to highlight two issues. One, that it is preempted by the National Labor Relations Board. Two, the bill itself, just technically, it creates confusion, which should ultimately be preempted as well. This agency creates a de facto shop steward, if you will, and that creates confusion. Some of the parking garages will be our union. If there are conflicts between any collective bargaining agreement and what this ordinance says, what prevails? Second, the PPA, that is a state agency. The way this bill reads, it includes PPA. If they too are union, where does the bill prevail? How does the bill prevail? And lastly, because we believe this bill sets a bad precedent. Right now, it's the parking industry. Next time, it could be hospitals. Next time, it could be restaurants, car dealerships. It could be all the industries that services all of Philadelphia. And I think we run into additional conflicts as a result. But Marjorie, she can explain about the labor issues.
Thank you, Marjorie Obad. I appreciate the opportunity to be able to speak here today. Sorry. As outlined, we submitted a letter to Councilwoman Parker last week on this issue, and it's outlined in that letter. The ordinance is preempted under the National Labor Relations Act. States are permitted to regulate minimum requirements for employment, such as setting a minimum wage. I heard a lot today about poverty, and minimum wage is legally permissible. You can set a minimum wage. That's a minimum standard that is not preempted. I just want to be clear about that. I also heard a lot today about job security, and there was a case in the Virgin Islands at the Third Circuit, which is binding here in this area, stated that where you just have provisions such as saying you can't terminate somebody, or where the employer's policies are enforced, where you can terminate somebody if they're being dishonest, if they're not doing their work, if they're not showing up. Those are standard minimum issues with respect to discharge, and those are permitted. That same Third Circuit court said when you're starting to get into substantive issues that affect the interplay of the free play of economic forces, which is what we're saying this ordinance does when it has a grievance procedure, when it asks for an investigation, where it talks about progressive discipline, where it creates a situation where the employees have the right to go to an agency that is not yet formed, who would be acting as the shop steward. I do labor negotiations, and when you have an employee who is grieving, when they're grieving, the union sends somebody with them to represent them at the grievance hearing. There's none of those provisions here, yet this ordinance, as it is set up right now, provides the same sorts of benefits that a union provides. What unions provide is they provide job seniority and they provide job security in these sorts of forms. And this is what the Third Circuit in that Virgin Islands case said is not permissible because it goes too far. The ordinance is not a minimum requirement because it is being broadly applied to all employee-employer relationships. Parking employers are being singled out, and this kind of piecemeal regulation goes to what Darwin said before. Is that something that you can then say would apply to any other kind of business? And the issue there isn't, should the employees in other businesses make sure that they have a minimum wage or make sure that you're not doing things, like I said, at this minimum standard can't be applied. But what happens when you have, as was testified to earlier today, 149 different parking facilities? So this same procedure of what the grievance policies are is going to apply the same to a lot that has one employee or two employees, an outdoor lot, as it is to an organization that has 10 different facilities. That distinguishes it in a huge way from the Fair Work Week. The Fair Work Week, which has a minimum wage and is talking about changing fair hours, giving notice if you're going to change hours, that is targeted just to employers who have more than 10 locations and more than 250 employees. So this policy, this ordinance, which has all of these areas where pretty vague. What are you going to do? How are you going to decide what an investigation is? How is the person who has a small lot and one or two employees going to decide what an investigation can be? What happens when the customer complains that there is a sign on the window of a small lot that says taking a break, and what that break is the bathroom break that the employer is required to give that employee under the American with Disabilities Act. Legally required to do it, yet that employer is now going to have to go to a hearing because the ordinance provides for the employees to go directly to getting hearings on these issues. So instead of having the dialogue just be between the two of them, which is how it works typically, unless you do get a union, they're going to have to deal with all of those issues. That is burdensome in a way that taxes aren't, because it's not even being fairly apportioned among the different parking facilities. The ordinance raises practical considerations as to whether the city is going to fill the role of the shop steward and whether the city is going to be the council of grievances. I heard about 2 or 3 more people being involved, and I had heard earlier that, well, we don't know how many people are going to complain. But when someone does complain and they're given a right in an ordinance that they are entitled to be in a court, you can't take that away from them. We can't finally say a couple months from now, oh my gosh, we didn't realize there'd be 1,000 different complaints. Who's going to represent these people in the grievances and take it away? There you're taking away a right. So this needs to be addressed before it becomes law. Collective bargaining agreements generally provide for an internal grievance policy, but there's no infrastructure here, and it pushes the employees to go straight to court. It does not take into account the different employees and supervisors and the relationships they have. I've spoken to some of the parking facilities, and some of the employees have situations where they're actually parking for doing valet work too, and so there's a lot of different considerations on what different circumstances these employers have. The Third Circuit, as I said, addresses this issue very clearly in the Virgin Island case, where they specifically say what kinds of minimum requirements can be put in place. And our position is that, as it is stated right now, the ordinance is illegal, and that you can put in place the things that I've heard about today as complaints. I've heard about poverty. There is nothing in what I'm saying today that would in any way inhibit putting a minimum wage in place. The other thing that I heard about is that there was some issues about talking about job security. As I said, the Virgin Islands gave guidance on that, but I can also tell you that right now, there are not complaints, we checked at the Pennsylvania Human Relations Commission or anywhere else, about problems that employers are having with the employees. So although there may be an issue about the poverty issue being a concern to City Council, I think with respect to the complaints, you need to look at whether or not there have been complaints filed. I've heard the contrary, that the employers have good working relationships with their employees, and if that is accurate and what's needed is more minimum wages or these other issues, then it isn't the place of the city to get involved in this when it's preempted and it's illegal. Thank you.
I want to thank you all for your testimony, and just want to push back a little bit on some of the comments that I've heard from this panel. And one of the first issues is the proposed ordinance imposing a just cause standard upon parking employers for all employee terminations is almost certainly preempted in whole or in part by the National Labor Relations Act. And I know we're going to have some other attorneys who are going to speak to this issue later. However, I want the viewing public at home who are not in this room to know that we don't move forward with this legislation without the blessing of the City of Philadelphia's law department. We check with the city's law department, and they have communicated to us that the claim of preemption under the National Labor Relations Act did not impress our city solicitor as a strong one. States and localities may legislate substantive protections for employees, and they frequently do, as long as the particular law is neutral in its treatment of unionized and non-unionized employees. The law will not be preempted on the grounds of conflict with the NLRA. While many such worker protection laws include an opt-out clause for workers covered by collective bargaining agreements, such clauses must be carefully worded in order to require a clear and explicit waiver of rights provided by the statute or ordinance. I don't believe such an opt-out clause are necessary in order for the ordinance to maintain the required neutrality. The presumption would be that all workers are covered by the law's protections. If there is a CBA in any of the parking employers' lots, the protections of these ordinances should still apply unless they are bargained away. I know the lawyers from 32BJ are going to talk to this fact later. In addition to that, I want to note for the record that the claim that the city has no authority to regulate the PPA based on state law, I'm a bit confused because all my bill does is amend a part of the city code that already refers extensively to PPA. For valet parking operators, the PPA already requires applicants to submit a plan that provides for sufficient staff to handle the projected number of vehicles to be parked during all hours of valet operations. My bill just amends the language to clarify the requirement that applicants submit a plan that provides for sufficient staff to handle the projected number of vehicles to be parked during all hours of valet operations and to maintain good order and ensure the safety of employees and customers. That's it. My bill adds 13 clarifying words to already existing language in the city code. I just wanted to note that for the record. The chair recognizes Councilwoman Gimp.
Thank you very much, Madam Chair, for that clarity. I have a couple of questions for Mr. Wonderling. Where was the chamber on paid sick leave?
We were opposed, that we're engaged in a process that occurred over 2 years.
Where was the chamber on, what was the chamber's position on Fair Work Week?
We were opposed, but worked with you specifically and many of our volunteer leaders, along with organized labor, on a stakeholder process lasting almost a year. And thank you for your leadership, for listening to the business community and including amendments to clarify the matter.
And what is the chamber's stand on raising the minimum wage statewide?
We currently do not have a formal position on raising the minimum wage state line, but are open to conversations if it's part of a broader package around regulatory reform. And that is also consistent, not to speak for, but other business organizations around the Commonwealth, because we think that that is the appropriate governmental venue to deal with minimum wage.
And what is your position on municipalities being able to eventually raise the minimum wage?
Again, we don't have a current position on that at this point in time.
And then a couple more questions, because I know you raised the question about HR. Do you believe that companies should be able to discriminate or fire individuals on the basis of race?
Again, you're taking the question out of the context from my testimony. My statement was related to, and I think buttressed by the comments of council, and that is currently this city government has no administrative capacity to implement the bill as drafted. That's where our concerns lie. We'd want to be part of a stakeholder process where we could understand that better.
Right, but I think you made a broad statement about whether or not the city should be involved with HR type of issues.
In all due respect, Councilperson, my specific language was related to the testimony on this bill, which currently as drafted has the city currently has no administrative capacity to administer.
Understood, but it was almost identical to the testimony that you gave on Fair Work Week, which is that you were opposed to the city being involved with establishing standards that generated anywhere near HR.
Generally speaking, on these legislative matters, we've been raising for at least the last 3 years opposition to the city government's ability to administer in the way that would serve the employee and the employer well, if nothing more to do so efficiently. We know that our city government is vigorously working to attempt to modernize its practices, but yet for many a city resident and business, oftentimes just an administrative process where there's a grievance involved takes an awful long time. That's not fair to the employee or the employer. That's why we make that broad
statement. Is a
statement.
determination that I think we can discuss further, but I think my issue is that repeatedly you've taken the position that the city of Philadelphia should not be involved with HR issues. And I would like to remind you, though, that the Constitution and other documents make it clear that we cannot discriminate on the basis of race. You cannot discriminate on the basis of gender. You cannot discriminate on other constitutionally protected areas, and that we are consistently going to make that clear, and that we are going to lift the floor. We're also going to enforce things that expand the floor for workers, and that this issue about just cause is asking questions that making sure that we don't discriminate on a whole set of issues, that decisions are not arbitrary and capricious, that they're not done in violation of labor standards or other protections when people are trying to unionize. All of those are protected areas. And so, you know, while I understand that you want to maybe have a conversation about boundaries about where we go, the question of whether this council or any governmental body has the right to regulate how HR issues type happens when it involves the constitutional rights and protections of our workers and of our employees and of our citizens is clearly established. And then, like, furthermore, I think, you know, what has got to be clear from our end is that in a situation where our people are struggling so much with poverty, and as we showed with Fair Work Week, that there's a clear sense that large businesses and companies have to meet us halfway, that we are here to raise the floor. I mean, we are here to be very clear that in a situation of poverty, we're raising the standard. We're not keeping it and lowering it to its lowest level that we can get to. We are the balance to a market that's merciless and unforgiving and is geared towards profit. We are here for people. So that's very important, you know, for us to recognize here. And then, you know, thank you very much to Mr. Beauvais and to the attorneys who are here. We did litigate, especially around collective bargaining. I appreciate the council member, the council chair, reminding us that the city solicitor's position is very clear, that the Supreme Court ruling on Levadas makes it clear that those collective bargaining units have a right to new protections. If this law passes, they do apply to collective bargaining units unless those units decide to waive that provision. You can't waive away rights that you don't already know that you have, or rights that are newly granted. So if we raise the minimum wage, we're going to fight to make sure it applies immediately to all of our collective bargaining units unless they decide to waive it. They have the right to waive. But the law does not call us to deny. The law does not call us to deny expanded rights and protections. This will be an ongoing issue of discussion, but I do believe that our city solicitor has ruled on this in 2 separate occasions, both in Fair Work Week and on this law. We'll be working to make sure that we bring our strongest efforts to the table to make that clear. It is a negotiated situation, but it's not unilateral denial of new rights that are given.
May I address that briefly? The issue there is that here the situation is that there is not a union present at the moment, and so the interplay also protects employers. The NLRA protects employers as much as it does employees, and the employers don't have the ability to opt out. So here, the situation is that there is language with a grievance with respect to the investigations, with respect to the discipline and progressive discipline that is so vague and unworkable for the employer that the only way to get clarity is to force them to enter into a union. That is not the free play. So that's the problem you have here. If you had a situation where you have unions already there and you're saying they can opt out because they have the language, but here the language, especially for the small lot, is going to be much narrower. So you're actually creating a situation where the only way an employer can have a workable situation is to enter into a layer of management that didn't exist before for the purposes of changing this to narrow it. That is not the basis for the latest case.
We are in this area already with paid sick leave. We're in this area already with the Fair Work Week law. We're in this area already with pay equity and wage theft. So there are new expanded rights. We can discuss them later, but this will be an expanding area, body of work that I think we're committed to, because we have an administration and a federal government and a state government that has abandoned these areas to the private market. So we're in a new area. But we are going to enforce our rights as clearly as they are established by our city solicitor, and we can continue that conversation.
Okay, I appreciate it. Thank you very much.
And I know we have some time constraints, so I want to say a special thank you to Councilwoman Sanchez because we know what you have going on in your district right now. I want to chair recognizes Councilman Green.
Thank you, Madam Chair. Ms. Abad, could you provide that name of that Third Circuit case that you made reference to?
Sure. It's actually at 218 F3D 232. It's the St. Thomas St. John Tourism Association.
It's 218 Federal Third?
I'm sorry. I'm going to talk fast. 218 F3D 232.
Okay, so it's...
And it's St. Thomas versus Government of the United States Virgin Islands.
Versus USVI. Okay. And then you said you have an opinion on this matter in reference to this legislation that you could share, not only with the chair? Do you have some type of opinion?
We gave a letter to the chair.
Okay. All right.
Our
Right,
legal
yeah, which I think was shared with, I think that's where we got the input back from
Okay.
the city council, the city solicitors.
Right.
I think that Councilwoman Parker was kind enough to say that she would share that with the
With
city.
the law department.
the law department.
And so my understanding that you're making a distinction between the other legislation that's been done and this because of the narrowness?
Well, specifically this case, it's specifically says that because the basis for terminating, which they give like 12 different lists as to what needs to be proven in order to terminate an employee, and it's a comprehensive list that says, if they perform work assignments in a negligent manner, if they don't abide by the employer's policies. And the court here specifically said that because it was drafted so narrow, that it's back to the minimal standards like the minimum wage. So that it's everything that they're putting in there as to when you can't get rid of somebody is comprehensive enough. This appears to be a comprehensive list covering all or almost all legitimate reasons for the discharge. So their position there is, all we're doing is saying every employer is always going to have to do this, as they always should, to Councilman Jim's point. You want to make sure you have things in place. They're going to protect the employees, but not getting into negotiating, which is what what we're saying is a distinction here, is when you talk about grievances and how that's going to be put into place, that is no longer minimum requirements, which is what the Virgin Islands approved in that case.
So just to summarize, so your perspective is that if it's a level playing field for all employers, that's not a problem. That's what happened in the fair scheduling, other legislation. But if it gets into the aspect of possibly negotiation between employer and employee, and that's what you're saying this legislation does, that causes a problem.
Because it would be different for, of the 149 parking facilities, if, they have different economic perspectives as to how they would negotiate these sorts of terms. They would all still be bound to that initial issue. They couldn't get rid of somebody who wasn't dishonest or didn't, follow their rules. Or I think even in the ordinance, there's also a provision about, if there's a downsize, the same issue here, that someone can only be terminated if there is a proven economic reason for it, so that all of the reasons that are legitimate reasons for discharge are addressed. They have to be met before someone can be discharged. That's okay. But when you start negotiating broadband to different employers of different sizes, those employers should have the ability to negotiate. That's where the NLRA preemption lies. That's our argument.
Well, I know there's counsel here from it may have different interpretations, so I'll be curious to hear their interpretation of this case as well. So thank you.
And I'm more than happy to discuss anything with them off, at any time to be helpful here.
Thank you, Madam Chair.
Are there any other questions for members of this panel? Seeing none, we want to thank you all for testifying. And because we have a scheduling conflict with one of our colleagues, we are now going to recess this hearing. We know we have 3 more panels to go, and we're going to hear from all of the panels, but we're going to recess this hearing. And so now I'm going to announce that we're going to go into a public hearing to consider the action to be taken on these bills today. And with that in mind, the chair recognizes Councilman Green for a motion on the amendment to bill number 190315. Not public hearing, public meeting, public meeting. Public meeting in motion for bill numbers 190315 and 190316. The chair recognizes Councilmember Green for a motion on the amendment to bill number 190315.
Thank you, Madam Chair. The amendment has been circulated to all members of the committee. I move that Bill number 190315 be amended.
Second.
It's been moved and properly seconded that the amendment to Bill number 190315 be approved. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed, the ayes have it, and the motion carries, and the amendment to Bill number 190315 has been approved. The chair recognizes Councilmember Green for a motion on the amendment to Bill number 190316.
Thank you, Madam Chair. The amendment's been circulated to all the members of this committee. I move that amendment to Bill number 190316 be approved.
Second.
It's been moved and properly seconded that the amendment to Bill number 190316 be approved. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed, the ayes have it, and the motion carries, and the amendment to Bill number 190316 has been approved. The chair recognizes Councilmember Green for a motion on Bill numbers 190315 and 190316 as amended.
Thank you, Madam Chair. I move that bills number 190316 as amended and Bill number 190315 as amended be voted out of this committee with a favorable recommendation with a suspension of rules so these matters can be heard at our next session of council.
Second.
It's been moved and properly seconded that bill numbers 190315 and 190316 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of these bills at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed, the ayes have it, and the motion carries, and bill numbers 190315 and 190316 as amended will be reported from this committee with a favorable recommendation, with a request that the rules of council be suspended to permit first reading at the next session of council. This concludes the business of the committee
Madam
on
Chair.
labor.
Can I say a comment before?
Sure, on Councilwoman Sanchez.
Yes, for the record, I think it's important, and I'm sorry that I have to leave the chambers. We're doing an affordable senior housing project in my district that I've been working on for the last 5 years with the mayor in North Philadelphia. I just want to add to the discussion. I want to thank the chairwoman for her willingness to work to find some level playing field when all things are not equal. And I know that when we're trying to legislate, we don't legislate for the perfect, but we don't let the perfect be the enemy of the good as we work through this process. We're in new territory. Economic justice for workers in the city of Philadelphia is huge. And I wish we could sit here and say that all businesses are good. There are a lot of good businesses, but then there are some folks who take advantage of some of the workforce in the city of Philadelphia. With a poverty rate that doesn't move, in deep poverty in districts like the ones that I represent, us challenging preventional thinking, legal minds, and legal statutes is exactly what we're supposed to do. As a council person who works extremely hard to represent the folks in the district, you know, I'm going to push back on this notion that we can't do something.
That's right.
We can absolutely do something, and we can challenge laws, and we can go to court, and more importantly, we can send a message. If you're a good employee in the city of Philadelphia, we're going to hold you up high, and we're going to thank you for the work that you do. And if you're a bad one, we're going to call you out and say you have to do better. That is what I get elected to do. Happy to work with everybody around that.
Thank you, Councilwoman Sanchez. Chair recognizes Councilman Green. You right? Chair recognizes Councilwoman Gill.
Thank you very much, Madam Chair. And, I just wanted to say just a few remarks, especially to the folks in this room who may not have known that the bill is going to move forward. It is, again, as my council colleague just said, an important area that we are going to be in. We have to expand and understand the power of local municipalities to establish the protections that our state and federal government are not doing right now. We have not raised the minimum wage in 10 years. We cannot allow these poverty wages to continue. We are keeping people at the mercy of as we heard earlier, a market that is unforgiving and is geared solely towards profit. And that's where local government government comes in. That's where municipalities come in. We have the right and responsibility to ask ourselves what more we can do. We cannot allow only, we have powers within our local authority that give us things, an ability to move things faster than what can be moved at the congressional level, so that we don't have to wait for DC. Senator Elizabeth Warren has been waiting for years to pass a Fair Work Week law at the congressional level. In Philadelphia, we moved it in 10 months, thanks to the people in this room. Harrisburg has waited for far too long to raise the minimum wage. It's the people in this room who are putting poverty on the front burner, who are waking up our good businesses and companies, who also recognize that growth, like a $7.25 an hour minimum wage, $2.83 tipped, is not a path to profit. It's a path that has slowed down Pennsylvania and Philadelphia's economic growth. Jersey's going to $15 an hour. We can't be leaving our people behind. And we'll be standing with folks, and I'm sure as heck not going to allow a bunch of lawyers in the Chamber of Commerce, which has opposed every single labor law that has moved through this city and pays its executive director over $600,000 a year, $320 an hour, hundreds of times more than the minimum wage, to be telling us that this isn't our world. This is our world. We will exercise it. We'll do it in collaboration with our employers and with the folks in this room, and we'll set a new floor. Thank you.
This concludes the public meeting of the Committee on Labor and Civil Service. We will now go back into our public hearing to hear testimony on bill numbers 190315 and 190316. Will the clerk reread the titles of the bills again? Is it necessary for you to hear? Please call the next panel to testify.
Robert Zaritsky, Harvey Spear, Charles Newkirk, and Michael Powell.
Cherelle, come on. Who wants to go first? I can. It doesn't matter. You go first. You sit up there.
You guys sit here.
You go first.
Mr. Zaritsky, Mr. Spear, Mr. Newkirk, and Mr. Powell, I want to thank you all for being here. Please feel free to just state your name for the record and then proceed with your testimony.
Harvey Spear, Easy Park Incorporated.
Charles Newkirk, Parkway Corporation.
Michael Powell, Parkway Corporation.
And Robert Zaritsky, Parkway Corporation. Yeah, go ahead.
Okay. Thank you. I want to thank you. My name is Harvey Spear. I want to thank you for giving me an opportunity to speak to you today. Easy Park has been in business in Philadelphia for more than 50 years. We are now a fourth-generation parking company. We find this has become it's become very difficult to remain in the parking business. All parking companies in Philadelphia pay approximately 50% of their income to taxes. Then we must pay our expenses, insurance, payroll, and especially employee benefits. The newest idea, sponsored by Councilwoman Parker, is asking us to pay a minimum wage of $15 per hour and an approval from a newly formed committee to decide whether we can terminate someone who breaks our company policies. We have a number of long-term employees who have been with us for over 20, 30 years, some of which are behind me right now, and some of which are new employees. We give a full benefit package, which includes 100% paid health insurance, as opposed to what you've heard from other people. We pay almost $15 an hour to start. We give a full package that includes bonuses throughout the year, paid vacations, 50% paid of dental insurance, and our industry is constantly being undermined by false accusations. The companies you see here pay more than the, whatever you said, $9.50 or something. And I have some employees here can tell you they've been here a while, and one of my employees became a supervisor and a general manager. I hope you can keep the parking companies in business in Philadelphia and understand our problems. Remember, people do not come to Philadelphia just to park their cars. They come to visit cultural attractions, restaurants, and they come to work. We are told that this amendment in council is unconstitutional. I don't think any business can exist under these conditions. Thank you, Councilwoman Parker.
Good morning. Thank you very much for giving me this opportunity to speak. My name is Michael Powell. I'm one of two business directors with Parkway Corporation. I have been employed by Parkway for over 35 years. I started as a parking lot attendant in September of 1983, and I've worked at every level throughout the company's operation. I have worked as an assistant manager, field manager, facility manager, district manager, and currently as director of business. Parkway Corporation has given me the opportunity to be successful and grow in my career. As a company, Parkway has demonstrated that caring for its employees is paramount to the success of the company. As one of its leaders, I have seen firsthand how Parkway provides benefits for us as employees, such as health insurance, 401k retirement plans, short-term and long-term disability, holidays, vacation, and sick time. Parkway's benefits ensure that our current living condition, as well as our future and retirement, is secure. My tenure here is one that I am proud of and would recommend Parkway for any employee to work. I have been privileged to supervise employees from all walks of life, and I'm proud to see the impact that Parkway has made in the lives of their families. Thank you.
Good morning. My name is Charles Newkirk, and I'm a lifelong resident of Philadelphia, and I myself have been working for Parkway for over 40 years. During my years at Parkway, I progressed through the ranks just like Mike Powell. It's probably not a job that I did not perform at Parkway, and currently I'm the Director of Operations at Parkway. Over the years, I've had many employment opportunities to work in other places, but I made a conscious decision that I wanted to remain with Parkway. And some of the reasons that I decided to do so was because, first and foremost, it is a very close-knit family atmosphere within our company, number one. Number two, it's a good thing to be able to know the owners of the company, and the owners of the company know you and know about your families. I've made a decent wage. And then the last reason is because of the caring and loyalty that I know that Parkway makes to the employees that we have on our staff. I've personally witnessed it, and being on the operations side, I see all the decisions that are made, and they're very conscious efforts to make sure that we look out for the staff that we have working for us. I've been able to raise my family working on Parkway's wages, and I did not start where I am now. I put 2 kids through college. I've purchased homes. I've been able to take vacations. And now I'm looking forward to the day that I'm going to retire soon from Parkway. So I thank you for allowing me to make those comments, and thank you very much.
Thank you. Thank you, Mike and Charlie, and thank you for letting me speak my concerns today. I'd also like to thank all the representatives from all the parking companies that are here today. If you could stand up and maybe just wave so you could be acknowledged that there are a lot of people here representing the parking industry today. My name is Robert Zaritsky, and I am President and CEO of Parkway Corporation. I also serve as the President of the Philadelphia Parking Association. We represent 15 local parking operators and owners of parking facilities throughout throughout Philadelphia. Together, we currently employ around 2,200 people. Used to be 2,500 people, but so many facilities have been closing so quickly, we're down to 2,200. Now, along with other concerned businesses, we see a crisis impacting every industry in the city, one of which, as a result of the burdensome and excessive regulation and taxation specifically aimed at our industry. For the last 10 years, taxes have continued to go up on the parking industry to the point that parking is the city's highest taxed industry. The result has been 10,000 fewer parking spaces in town. At a rate, we're losing about 1,500 spaces per year since 2015. This is causing traffic congestion and, unfortunately, the loss of 300 jobs. 50% of the city's tax base comes from jobs generated in Center City and West Philadelphia. If those areas don't have an adequate number of parking spaces, the city risks ending the successful run we've had in creating jobs, incenting employees to relocate and expand here. 50 cents of every dollar you pay to park goes right to the city in the form of 9 different taxes and fees. As a result, we are losing parking spaces and parking facilities and the jobs that go to support them at a dangerous pace. And no one is building back parking because the costs to build in Philadelphia are so high and the taxes are the highest in the nation. If enacted, these bills would further burden our endangered industry, and it would put to risk the 2,200 jobs which currently are in the city. Parking is still a vitally important part of the transportation infrastructure that enables people to go to work, see their doctors, stay over at hotels, and shop. Not everyone lives near public transportation and can afford ride sharing. Thank you for your time. I just want to mention a question that Councilperson Green mentioned, which was about the auditing of our industry. And the oversight of our industry, we believe has been, there hasn't been any oversight on our industry. Ironically, we as an association have been asking the city for oversight of of the parking industry, which is counter to probably any other business in the history of the country. We wanted the city to go after bad operators in the city. We know that we identified ourselves over 100 parking facilities that were not licensed, and if they're not licensed, they probably weren't paying their taxes. And we went to great lengths. We identified an auditor and suggested it to the city. The auditor was actually hired by the city and found, I think, 47 parking facilities that were in violation, and the city didn't act on them. So it's a very odd time for the parking industry. We are under stress. I consider us on the endangered list in Philadelphia, and we need some tax relief and further making it more difficult to be in the industry means that even less parking will ever be rebuilt in the city, which is needed. Thank you.
I just wanted to agree with Robert Zawitsky that we probably are either developing or sold in the last 5 years. We used to have over 25 locations. We're down under 20 now. And we have plans now to sell or develop 3 other ones because the tax burden is enormous on us. And I also wanted you to recognize some of my employees that came. They're a little bit shy, but if you want to ask them anything, they can reiterate what I said about the pay scale, the benefits, and they're very happy employees, one of which came from another company when we bought something. So just wanted to explain that one.
Chair
Thank you.
recognizes Councilman Green.
Thank you, Madam Chair. Thank you for your testimony. Wanted to follow up on a couple things. Mr. Zawitsky, you brought up the audit that was done by you and others in the parking industry, and that was provided to, was that the previous administration? That was another administration? And has that been followed up at all with this administration at all?
No, it was, the last administration hired the auditor that we recommended. He came in and audited the city in January, one winter, cold month, and found a lot of the things that we had been, complaining about. To our knowledge, no one in our industry has been audited in the last 25 years.
Okay, and so that's information that can be provided to our revenue department, like Mr. Breslin and others, that we can follow up on that. So if you can maybe provide that information to the chair, so that way we can follow up with this administration and find out why those steps have not been taken.
Sure.
Also, I wanted to talk a little bit about the industry and get a better understanding. So my understanding is that Philadelphia Parking Association represents 15 local private parking operators and owners of parking facilities throughout Philadelphia. What are the nature of the other operators in the city? I'm assuming there's a larger corporations who are international corporations.
Yeah, the 15 is all our members, and the majority of them are actually large national companies. We're Harvey's company and our company, and maybe there's 1 or 2 others, are the only ones left in the industry. Most have sold their companies and they're long gone. We're like the last survivors in the industry. So yeah. That's the nature of the business now. Okay.
And you also talked about the fact the number of fewer parking spaces in town and how that's impacted loss of jobs and also industry. Can you give a sense? I understand that the tax and regulations, from your perspective, has had an impact. What else has had an impact on the industry?
Well, the construction costs are very high in Philadelphia. They're the highest probably in the country. So developers choose to build things that they can make money from, and they've determined that because of the taxation and because of the construction costs, parking is not viable anymore. Now, technology is changing too, and car sharing and Uber and Lyft is also negatively affecting our industry as well. So there's less parking that will be needed in the future. Our concern and our contention, and the reason that we have been lobbying the city for years, is that when it gets down to when there's not enough parking spaces in Center City to support the economy, you risk the entire economy of the city. The airport has plenty of parking. The stadiums for the Eagles game probably has enough parking. This is Center City in West Philadelphia, where 50% of the jobs that 50% of the taxes come out of West Philly and Center City. And if the jobs, if you can't support the restaurants where the parking rates go up too high, then people are not going to be coming downtown to go to the orchestra. They're not going to be going downtown to the restaurants or see their doctor. They'll go to a doctor in another place. And people will continue to move their businesses outside the city. And that is what we are most concerned about. It's not so much the bill makes it more difficult to be in the parking business. The taxes make it impossible to be in the parking business. So that's why we have been pleading with the city for tax relief and to audit. We think we're a good company. We think we're a very good company. We think Harvey's a good company. But there are bad companies out there. We have been the ones trying to police the industry and point them out to the city. There are bad companies. They're bad, but when you overburden the taxation, you give an advantage to the people that are cheating, right? Because they're not paying the taxes. Right. So it's this weird dynamic of overtaxation and we think overregulation gives an advantage to the bad companies and forces the good companies to leave.
And it's also those companies who are also most likely not only to not pay their taxes, but also treat their employees in a substandard way and also pay them minimal salary.
Harvey and I, we spend a lot of time on this association. Our company, Parkway Corporation, starts our salaries. The average salary for a parking person starts at like 13 and a quarter. So this $9.50 rate average for our industry, I don't agree. I don't know where that comes from. That wasn't. They didn't survey our employees, I guess. So I don't know where that comes from, but.
I'd like to add to that too, that our company starts around $12, $13 an hour, and most of our employees make substantially more than that. And I think that we may be one of the only companies that pays 100% company benefits, which today is very difficult to maintain because the benefits keep going up. And we give them, as I stated before, health insurance and everything else.
Yeah, and so the issues you raise about the fewer parking spaces and the reduction of parking impacts not only your corporation, but also impacts those who are here who also support the legislation. So I think the issue of taxation is an issue that I know the Councilmember Parker, chair of this committee, has stated she was going to aggressively look at in reference to reducing taxation. But I'm also curious about your thoughts on on-street parking versus parking lots. And what role that plays in this issue?
Well, our rates for on-street are $3, and our rates for off-street could be $18 to $22. And on-street doesn't pay taxes. They don't pay utility bills. They don't have to pay rent. And most cities are way ahead of $3. Some cities are as high as $8.50 for that same hour. So we think and when you have people, when the rate is so low on the street, it causes more congestion because, like, I would go looking around for a metered space because it's $3. It's like the best deal. It's right where you want to be, in front of your store, and it's a tenth of the price or whatever that difference is. So we think that there should be more parity between on-street and off-street. Parking gets blamed for causing congestion. It's the opposite. Parking takes cars off of the street. It causes less congestion. Meters on the street actually cause more congestion because everybody's looking for those spaces. And pulling into parking on these narrow streets we have in Philadelphia causes more congestion. So we think there is low-hanging fruit to kind of balance this out, share the tax burden with some on-street fines and fees, and balance out the onerous taxation on our industry. It's no other city has this. Boston has a 0 parking tax. Los Angeles, which is a car city, has a 10% parking tax. We're 22.5%, plus we have a use and occupancy tax that no one else in the country's ever heard of. That's like 85% of the real estate taxes. It's brutal. It's a brutal business to be in now.
I want to add that we also have a stormwater tax to run the water into the sewer, which is substantial now, in addition to the other taxes. And after all that, we pay our insurance, labor, and everything else, which comes to about 50%.
Okay. Thank you, Madam Chair.
I want to thank you, Councilman Green, for your line of questioning. I want to thank the panel for your response. Let me just note for the record that the issues that you just got on the record today, it's not the first time that I've heard them, because when we met, you shared those issues with me. And I was very transparent in saying to you, while we may agree to disagree on the bills being proffered here today, that we heard your concerns regarding the taxing structure, along with the rogue operators who currently were not being monitored. And you communicated all of that to me. And my commitment to you, just for the record and the benefit of those who are watching at home who are not in this room, that it is not as if this legislative body, and I can specifically speak for myself, did not say that there were some very concrete issues that you raised, and that the difference was, and I don't know what happened during the last administration, because, you know, I was not here. I was in Harrisburg getting a few things taken care of. And but when we committed to doing something, we worked to get it done, and we assured you that from the auditing and working with those who are not paying their fair share, along with the tax structure, that after we finish these bills, to make sure that the employment security that the workers deserve, that they earned, that they should get, after we work with those bills, that work to get these bills passed, we would not abandon the industry. I mean, that is what we said. So again, anybody who is watching at home, who, you know, I want you to note for the record the communications between the industry and as the chief sponsor of these two bills, that we have not turned a blind eye to what you said were the concerns. And to me, I thought it was, you know, it was pretty significant, because I'm always looking for a win-win. And if we were going to address the challenges that the industry was facing, I said to myself, wow, wouldn't the employees that we see sitting here today who are here to support this legislation, wouldn't it be great and a wonderful and a more perfect world that they became your allies and not your adversaries? Thank you. Thank you so very much for testimony. The clerk will please call the next panel scheduled to testify.
Kachin Locke and Jim Runkle.
Thank you both for being here. Just please state your name for the record and proceed with your testimony.
Kachin Locke, Associate General Counsel, SEIU, Local 32BJ. Thank you to the committee for having us here. I'm going to address briefly the legal issues that have been raised by the parking industry lawyers, although you guys have done a pretty good job of responding yourself, so I'm going to be brief. The National Labor Relations Act regulates workers' rights to organize and the collective bargaining process. The bills presented here today have nothing to do with that. I'm going to go right to the Third Circuit case, the Virgin Islands case. What the industry lawyers failed to...
Excuse me, can you just please... excuse me. I'm going to ask everyone who's leaving the chamber if you could please do so quietly so that we can make sure our stenographer is getting the testimony of this current panel on the record accurately. Thank you. I apologize for the interruption. Please proceed.
No problem. The Third Circuit case, which was raised by the industry attorneys, involved a just cause statute. I don't think that came out clearly in the testimony, but the Third Circuit squarely held, i.e., in non-lawyer terms, the main point of that holding is that a just cause statute, in that case Virgin Islands, was not preempted by the NLRA. That was the central holding of the case. It was a just cause statute. So what Philadelphia is doing here today is nothing unusual. There are 3 just cause statutes in the country right now. Montana, my home state, 1987 passed a just cause law. Virgin Islands, Puerto Rico, those have been on the books since 1986. This is nothing unusual. These have been around, they have been administered with no problem, and they have been upheld by the courts. The National Labor Relations Act regulates bargaining conduct such as strikes, lockouts, those types of things. The just cause statute has nothing to do with the bargaining process, and so as the Third Circuit has already held, completely outside the realm of the National Labor Relations Act, and so it is not preempted. Philly has the authority to pass this. It's a home rule municipality. You've got the power to do everything so long as it's not in conflict with state or federal law. It isn't. This is akin to what you have already done, the important measures you've already taken with paid sick and fair scheduling. So that's the NLRA preemption argument. I just want to raise one point to address that. The industry lawyer's final point was that this bill doesn't address poverty. And if what we're all talking about here is trying to address poverty, she argued, this isn't the right bill to do it. There is a reason that terminations in the workplace are called the capital punishment of the workplace. Because when you lose your job unfairly, you lose everything. You lose your money, you lose your ability to raise your family. So it does address poverty. It prevents unfair termination and protects people's livelihoods. Thank you.
Hi, Jim Runkle from Spear Wilderman, representing 32BJ here locally in Philadelphia. Chairwoman Parker, Councilwoman Green, thank you for the opportunity to testify today. I've been practicing labor law, I hesitate to admit, for more than 30 years now here in Philadelphia, and I've spent the bulk of my time bargaining contracts. And as the Supreme Court said back when I was in law school, that both parties to a bargaining process walk in understanding minimum labor standards that have been set by state and local government. Everybody knows that's part of the game when you walk in, and you react accordingly. So frankly, as someone who's bargained 300 plus contracts, I was surprised to hear the employer raise the preemption argument here. This is clearly not preempted. It doesn't curtail an economic weapon of a party or disrupt the bargaining process at all. In fact, a just cause standard is the most basic, fundamental piece of any collective bargaining agreement. I bargained 300, one thing's for sure. There's a just cause and a discharge procedure in every single one of those contracts without exception. So it is, in fact, to give you one salient example, I think, I'm bargaining right now a first contract, those are the hardest ones to do, with an out-of-state employer that's a major trucking firm in Philadelphia. We've been bargaining for 6 months. Before we even started bargaining, the parties themselves entered into an interim just cause discharge procedure to deal with those kind of issues while the parties are bargaining, and so that the parties can move on to substantive economic items. That's how basic and fundamental it is. And another example too, this employer walked in from out of state, and one of the proposals was sick leave. So they did not express any kind of dismay or moral outrage that there's a sick leave provision in Philadelphia. Instead, they bargained over it, and they actually implemented the city's accrual rates into the collective bargaining agreement. My point here is that minimum labor standards that the Supreme Court has always endorsed and said is not preempted by the NLRA is actually helpful for both parties. You understand the parameters, and then you can move on to wages and benefits and other issues. So this is not a hindrance to a bargaining process. If there ever becomes a bargaining process here, it actually is helpful to both parties and doesn't disrupt the bargaining power or relationship or economic tools of either party to a collective bargaining agreement.
Thank you. Chair recognizes Councilman Green.
Thank you, Madam Chair. Thank you to both of you for your testimony. And I wanted to kind of further delve into this issue regarding the Third Circuit case that was made reference to by Ms. Abad. And she made a distinction between fair scheduling and this legislation in reference to the other legislation being different than this, and made that distinction in reference to it being preempted by the case law. So I want to get some perspective from both of you, both from Mr. Runkle, from your organizing and CBA negotiating perspective, and then Ms. Locke from your interpretation as well about that distinction that she made.
As a legal matter, there is no distinction. Just cause is a minimum labor standard for purposes of the preemption analysis, no less than fair scheduling. And the Third Circuit, again, was dealing with a just cause statute. Another decision, the DC Circuit ruled a number of years ago that a displaced worker law was not preempted. It's sort of the converse of just cause. When you're a building service worker in a building, your employer loses the contract to clean that building, another employer comes in and you are required to hire that employee, called displaced worker. DC Circuit upheld that law in the face of an NLRA preemption challenge. So just cause has been upheld squarely by the Third Circuit as a minimum labor standard. Displaced worker has, health benefits have, a number of other components that may end up in a collective bargaining agreement, but they don't necessarily have to. So there is zero difference from a legal perspective, a legal authority perspective, between fair scheduling and just cause.
And just one other piece, there was a distinction made in reference to fair scheduling being more narrowly tailored for certain types of businesses, where this legislation was broader and would impact the entire industry. And there would seem to be a distinction that was made, and that's what caused the fact that this could get into the aspect of collective bargaining. So I want to get your thoughts on that.
I think she was just wrong about that. I didn't agree with that analysis. The preemption analysis under the NLRA doesn't turn on sort of the narrowness or the breadth, one industry versus, in Virgin Islands' case, it applied to everybody. It's just not relevant to the analysis. What's relevant is, does it impact the bargaining process? And there is no bargaining process at issue here. It just exists outside the realm of a bargaining process. And so perhaps what she was talking about was the collective bargaining agreement opt-out in that decision. But it was actually the converse of what we're dealing with here. And so the courts will analyze a collective bargaining opt-out in their preemption analysis. And the reason for that is because the analysis includes an assessment of whether the ordinance treats union, non-union workers alike. If you have a provision in a statute that says this doesn't apply if you are covered by a collective bargaining agreement and that agreement expressly waives the underlying right, and the collective bargaining agreement has a provision that contains something akin to that right, that's where the analysis comes in. They analyzed that provision in the Virgin Islands statute and upheld it. And here, we don't even have that issue.
Right, and I think that's specifically why this legislation, from my understanding, was drafted to not include the opt-out, specifically for that perspective, so it would not bring these issues up.
Right.
And
now,
so,
it could, but it's not in the ordinance. It could, but it's not. And so it's
Right.
not even, the Third Circuit's analysis isn't even relevant here for that purpose.
Right, right. And so, once again, you stated that the just cause legislation in the St. Thomas case was not narrowly tailored. It was a just cause legislation and was a breadth of an industry type of perspective. So,
right, and that
okay.
that wasn't even part of the court's analysis, but it was a broader statute. Yes.
Right. Okay. Thank you. Okay. Nothing further, Madam Chair.
Thank you both for your testimony. Will the clerk
Thank
please
you.
call the final panel?
Donald Hayes, Gina Kane, Fataman Traore, and Gabe Morgan.
Derek, is it morning or afternoon? Is it morning or afternoon? Okay. I was about to say good morning, but it's afternoon now.
Yeah.
Right? Let me say good afternoon to each of you. Please state your name for the record and proceed with your testimony. And speak into the microphone. We want to make sure the stenographer can hear you and record you accurately.
Good Monday, Donald Hayes. Good afternoon, Gina Kane.
Good afternoon, Fatoma.
How you doing? Gabe Morgan.
Okay. Thank you to City Council members for hearing our story regarding minimum staffing. I am a downtown parking attendant. I have been on the job for a year and a half. I work a grueling split shift from 8 a.m. in the morning to 12 p.m. and 2 p.m. to 6 p.m. I need help. Right now, there are only 2 of us valeting hundreds of cars every day. We have to park the daily and monthly customers. We have to write down their license plate, exchange keys, and then move their cars downstairs. We snake through a dangerous one-lane driveway to park those cars. We don't have time to wait on the elevator. We have to jump to it. That means running up and down flights of stairs. Every minute counts. We have a customer that needs to get on with their day. Sometimes the demand of the job can have us both be downstairs at one time. That means no one is upstairs where all the keys are locked away. Anyone can easily access that lockbox, and those keys are gone as well as those fancy cars. We need a third person to keep an eye on that lockbox. A third person would help monitor the incoming cars when customers don't read and try to park themselves. We actually had a customer park their car and ended up hitting another car trying to navigate out of the lot once they realized it was a valet garage. That causes damages. When I go on my break from noon to 2, my colleague is alone. There's no one to help him at busy lunch hour. Our jobs are stressful and unpredictable. At any time, there could be 10 cars coming in. When I'm away, he has to manage that by himself. If he has to use the restroom, he either has to call a manager from another location or shut the booth down, leaving customers to wait. I am a floating attendant, so I work surface and closed lots. When we have to leave the surface lot, customers quickly call the numbers listed because they are looking for us to be on the site so they can get where they have to go. While our customers pay with credit or debit cards in our lots, a potential thief has no idea we may have tips. When tips are given, most people don't give tips, but our lives are at risk as people might think we are cash cows. More staff would help make a stressful situation less taxing. Thank you for taking the time to listen and work to bring about change for the hardworking parking attendants across this city. I just want to add, if I may, we had my particular location where I was, or where I am, we did very well. We did so good, we just had the supervisor just 3 days ago come to our location just to give us praise of the great job we're doing. And prior to that, one of the supervisors says, "Man, you're looking good. This location is making some profit, some money." So what that means to me is we know a bonus check is forthcoming. So on the 5th, one of the managers said, if it's not in the 5th, on the 19th, it should be there. If not, talk to me. So when the 19th came, me and my coworker, I waited a week, and then I asked him, I said, what about the bonus check? On the phone, he said, well, can I speak to you in person? Well, I'll come over and speak to you in person. So when he spoke to me in person, he said, about that bonus check, we missed it by this much. I said, well, your supervisor said, we're doing great. He said, well, it was this and that, and a little situation where, we didn't feel, a lot of talk. But then again, I said, well, your supervisor said, we did very good, we made some profit. And so we're missing, and my coworker was furious. So the other day, he stepped to the, approached one of the head supervisors over everybody, and she said, we're happy, because she did an inspection around the facility. She said, oh, I'm happy, I'm delighted. So he went out of the booth and he said, well, you happy, but what about us? What about our bonus? We didn't get our bonus. And her response was, head down and nothing. So that's just a story. That's just one. I don't want to go on and tell you so many other instances of workers being beat up, attendants being beat up, because, we have to turn the other cheek. We can't talk back to the customers, what have you. They could tell us, hey, this is the other day, because a client said, I'm running late. I've been waiting here for 5 minutes for you. Go get my car. Go get, hurry up and get my car. I said, hold up, and I said, I try to be professional, but I told her, a long story. I said, listen, after I got her car back, I said, I'm going to take my time. So she called the manager and reported me. But anyway, I just let her know that this is not slavery. Slavery is over. And her face was red. And then she just went off, and I just did not say anything to her. So, and then my manager, we had a long conversation. I told him, you know how I am? I don't take no mess from nobody. I'm respectful, I'm professional, but please, I'm not gonna have nobody, beat me up or what have you, disrespect me. So, and I'm not gonna really go off, but I have a few customers that when they come to me, I have them go get their own car. And whether that's protocol you're supposed to do, but because they complain when I get their car, they don't want me to move the seat, they don't want me to move the windshield, I gotta be cramped up to drive the car. I'm not gonna do that. So I say, here's your keys, it's in B32, go get your car. I don't have no problem with them. They respect me, they go get their car. So that's it for me, so I just wanna, give you that little testimony. It would have been nice if they would have heard that, who left, so they can understand that we, how we feel, really.
Oh,
Okay.
Good afternoon. Thank you, City Council members, for taking time to hear our concerns. I'm Gina Kane. I'm a park attendant at CHOP. Well, I'm gonna put the wrong thing on there, sorry. I have worked at this position for 5 years. It's 6. As a mother and grandmother, I fear for my safety while on a job. There are not enough people working. I work overnights, 10 to 6 a.m. During the weekdays when I work, there is security. On the weekends, there is no security. I am by myself in a booth with the door locked. The garage is open to anyone to gain access. There are homeless people who come up to the booth. There are angry drivers who get mad when I tell them that this isn't an employee lot only. I had people get mad and call me black niggers and all that results at me. When I need to use a restroom, I have to have a coworker relieve me, but security does not. Security does not. Security officers should not have to do our job of a parking attendant. If security isn't able, sometimes I need to call a coworker from another lot, but they don't always have someone to relieve them. My goal every day is to go to work and return safely at home. I shouldn't have to fear for my life and my safety while working to help others get their jobs. I want to put this on record, and not on record, but I'm 50 years old. This is the lowest paying job I ever had in my life. I've been at the job since 2014. I started with 735. I get 766. I can find 33 cents on the ground every day. I hold on. I've been applying for other jobs, but it's like, it ain't fair. It's not fair, and I just thank God for the job. I thank God, that I'm able to work for my health and strength, but in part, it's ridiculous. And thank y'all for listening.
My name is Fatoma, and I thank you guys, and I thank BJ32. And today is a new day. I can't believe I'm sitting here facing you guys. And I'm going to talk about the abuse we are taking from the import. And I've been working with them for 14, go to 15 years. And I have my paycheck here in my pocket. It's every year 10 cents. My question is this: how somebody who have family, wife, kids, grandson, live with $250 a week, and you have to pay rent for $900? So where is the American freedom? And if I try to express myself and I get fired for that, and I have a few examples here, they got fired because they try to speak with their mind. They don't want that. So we are taking some kind of slavery, like you say, and it's true. It is. This new slave master need to be stopped. It's true. Because if you stop me express myself, you stop me express my feeling, you control me if I'm going to the bathroom, and you control what time I eat when I finish, this looks like a slavery to me. That's what I believe. And it takes just 5 minutes to understand the whole thing. These people, they came with the paper. What they say in the paper, yeah, is the truth. That's the law, because you guys sitting here, they're scared. But what they do in the field is a different story. Yes. Since my 14 years with the import, I saw a lot of people in fire for no reason because they don't want to be on their sides. And I'm still valet. And some people might ask themselves, for 14 years you still valet, why you don't went up? Because I choose to. I don't want to join the bad side and fight my poor people. I'm not going to do that because we ask the same money. So I don't want to snitch, for them, because I don't want to do that. Yeah, and it is the truth. So we cross the ocean to come here to have better life. This parking, I've been in a lot of parking. It's the same thing. They speak in one voice using foreigner. Because if you take the parking lot, if you look at it, you will see maybe 60% is a foreigner. Some have a language barrier, like me. Maybe I speak a little bit. Some cannot speak at all. So they take advantage on them. You go by the rule or you get fired. Simple that. Anybody who crossed the ocean and came here to have better life, they say, we're going to fire you. You're going to think about your family. Who's going to pay my rent? I don't want to be in the street, so I have to go by the rule if it's wrong. That's what they do, and that's the truth. Yeah, a lot of people like me. This guy, see over there. He was coming in the parking lot. The parking was jammed. He just blew the horn just a little tiny bit to alert the manager. We have so many cars lined up. He turned around. He saw he's the valet. He just went off. Why you do that? I'm going to fire you. I'm going to make sure you get fired. Hey, they send him home. Why? Why they treat us like this? Because we just came here to have a better life? I believe America is a good land. Everybody have a right here. So we share the same thing. So they need to respect us. They have to. Yeah, that's all I have to say.
Mr. Morgan, before you testify, Councilman Green wants to ask some questions.
Yeah, I just have one quick question. Who do the three of you work for? What companies do you work for?
Impart.
All Impart?
Yes. Yes.
You're Parkway? Okay, thank you.
Thank you, Mr. Morgan. Please proceed.
I just point out that Parkway testified here today about what a great employer they were. So I think you've heard a lot of different viewpoints in this. I just want to remind the committee and also thank the committee for having this hearing, for listening to folks and for listening to both sides and for trying to find solutions to the problems that affect people in Philadelphia who most need the support. It's the working people of the city who most need the Philadelphia City Council to step in and look after their interests as residents in the city. And we really appreciate the time that you've given us today and having this hearing and sponsoring this legislation and caring about what happens to these workers. And so before I say anything else, I want to say thank you for that. So I just want to remind folks why we're here and why there's a hearing. I had some written testimony which we submitted, but there are things I hear today that said it better. I heard the Chamber of Commerce suggest to you that it's a huge problem if a worker takes a bathroom break. Remember, the lawyer said, what do we do in Philadelphia if the attendant has to put up a sign that says I have to leave my post to go to the bathroom? That tells you what this industry is. It's an industry where going to the bathroom is one where you risk your job in many, many companies. I'm going to read you some of the things that have happened in Philadelphia parking lots. The sexual assault in the garage under Love Park in 2016, that was in a newspaper. The sexual assault in a parking garage on 17th of Callow Hill in 2015. A shooting in a parking lot in Roswell Mall this past February. And just last week, an attempted abduction with a machete at a parking lot on the 1200 block of Fitzwater. The reason why we've asked for minimum staffing, for example, is because parking lots are dangerous. It's dangerous for customers, and it's dangerous for the people who work there. You don't have to take our words for that. You can just Google search your own bad things that have happened in Philadelphia parking lots, and you'll see many headlines that come up. And some of those things have been horrific, like the ones that I've named. But it's also the experience that workers have, where there's not enough people on the site, not only for a worker to be able to make sure customers are safe, but to go to a bathroom themselves. These are conditions that people in this country should simply not have to work under. And so enacting a law that says a company has to submit a plan to the city that ensures they'll have adequate staffing to make sure that workers can do things like go to the bathroom or customers can do things like not get abducted by a machete is not an over-the-top piece of legislation. And hardly one we can imagine that it will result in the wholesale closing of the parking industry. Just cause is really the most basic standard that you can give a worker. All it says is you can't be fired for just any reason. The employer actually needs to show that you did something wrong. They can't just walk up to you and say, I don't like you, get out of here, you're fired. They have to actually have a documented reason to say why they're letting someone go. And then a worker has the opportunity to, if they have done something wrong, to improve their work record over time to prevent termination. It doesn't stop an employer in case of some egregious event. If an employee steals a car or lights the garage on fire because they don't have a bathroom, something that lets them be instantly terminated. It doesn't stop them from doing that. It simply gives them the most basic protection that any worker can have. And so that's all we're asking council to do. If, as the industry maintains, having enough people to ensure the safety of its customers and its staff, or having to make sure that everybody works with them basically is treated fairly, will cause the whole parking lot industry to collapse, then I think it's an industry that should take a very hard look at itself before it comes to council and asks for a tax break. And I think that to us is, the other argument that we need to address here. Philadelphia parking has a high tax rate. It's true. Philadelphia parking is also booming. There have been closures of lots. A lot of that has been by the very folks who sat here and actually converted their lots into large-scale residential and commercial buildings after getting a tax break from the city, a handout from the state, and then had the nerve to come here and complain about closing number of parking spaces. A number of the companies that testified today are the very companies that actually receive the most public subsidy in the form of city contracts, RCAP money from the government, development variances, etc. Are those same ones coming here and complaining to you about having to have the burden of treating their employees fairly and make sure their employees and customers are safe? The way this industry works is there are essentially 4 kinds of parking lot operators that we can see. There are multinational corporations that are booming all around the world, which does, you have to raise the question why, if parking is such a terrible industry in Philadelphia, there'd be so many multinational corporations fighting for work here. There are local contractors that just do parking. Some are small, some are big. And then there are the bigger local contractors who really their main business is actually to be developers. And all of those folks are then hired to compete for business, in this case, ironically, by large-scale commercial office and residential buildings that actually, with their own employees, which 32BJ represents, security officers, cleaners, building engineers, are actually receiving significantly higher wages, have basic things like just cause, have had them for a very long time, have health insurance, have pensions, and it turns out, even though we've had those things, it's not resulted in the closing of downtown Philadelphia. So I think we would ask council and thank council for moving forward with this today. We're greatly appreciative of that. And I think council recognizes that a lot of the arguments that they've heard today don't make sense. To come up here and suggest that the exact same Supreme Court case that actually made sure that just cause has been ruled across the United States of America to be not preempted, to then come up and cite that case as the reason why it is preempted, for example, to say, to suggest that the plague of Philadelphia is all the affordable on-street parking. It's tough for you to imagine that people in Philadelphia are running around saying what the real problem is here. There's too much affordable on-street parking. I don't think that there are a lot of Philadelphians who are saying, you know what, the real problem here is parking taxes are too high. Parking taxes may be high, but you're an industry that pays people terribly, treats people even worse, and then comes around and asks for a public handout from that same tax money that they got from the city. So we look forward to working with the committee and with the members on council to pass this legislation to protect parking workers in the city going forward and in other industries. And we appreciate the offer, Councilwoman, that you made and made sense to us, that instead of having an industry be at odds with its workers, if that industry would sit down with its workers and figure out how to become better employers, the loudest advocates for improvements to those industries would be its workers. In the same way this council has seen us come in and advocate for some of the biggest building owners in the city who actually have created 4,000 or 5,000 family-sustaining jobs for working Philadelphians within these same 15 blocks that the parking lot industry is claiming that it can't. So thank you very much for your time.
Chair recognizes Councilman Green.
Thank you, Madam Chair, and I would like to thank the panel for their testimony, and also thank you for restating, which may have been lost, that just certain basics, human dignities that people should be able to have in working, like just the right to be able to go to the bathroom is just a basic right that anyone should be able to have, no matter where they work. So thank you for putting that on the record. And also, Mr. Morgan, also thank you for putting the information about not only the human dignity of being able to go to the bathroom or take a break that any person should have, but also the public safety issue, because I don't know that came out as much that being in a parking lot as an employee or as a customer late at night, even with lighting, can be a public safety issue. And so I'm curious what type of staffing occurs in other cities or other jurisdictions that may or may not be used to address that issue.
So I'd say a couple of things. I'd say one, there's a trend to automating a lot of this, which actually the leaders of that movement in the city testified here today. That may or may not be a good thing to do, but if you automate and then you don't ensure that there are at least adequate staff or security or what have you to ensure that people are safe, then you are creating a potential problem. In effect, a problem for the city and for the city police to deal with anyway. We, in this legislation, actually felt like because lots operate differently, what's in a large hospital lot versus what's in an isolated parking lot is differently. We really did feel like the right place to put that decision on what the sufficient number is actually the folks most in charge of the safety of the residents of Philadelphia, which is the city of Philadelphia. And so the ordinance really doesn't try to make everything a cookie cutter. It says submit a plan to L&I so that L&I can review it and ensure the safety of residents, workers, et cetera. And then also, for the first time, believe it or not, give those folks, customers, workers, an actual number or something they can call if they experience an unsafe situation or think an unsafe situation is going to happen, which currently doesn't exist. So we thought rather than give a cookie cutter number, because what it looks like in different cities or in different lots is even different. Why don't we entrust it to the city to make sure that they're required in order to operate in the city to provide a basic number of staff to make sure that's safe? I hope that answers the question.
Thank you, Madam Chair.
I want to thank you all for your testimony. Let me just ask, is there anyone else here to testify on these bills? Seeing none, this concludes the public hearing of the City Council Committee on Labor and Civil Service. I want to thank you also very much for your patience here today. Thank you.